Hello everyone, this is Tom Fox and I'd like to welcome you to episode 134 of the FCPA Compliance and Ethics Report. In this episode I continue my discussion with the FCPA professor Mike Kaler. We take a deep dive into some of the comments that Judge Rakoff recently made in a New York Review of Books book review, comments by Judge Leon from the bench about proposed DPA in the export control area, and continue with some of our joint thoughts on the use of DPAs and NPAs. The episode comes in just under 20 minutes. I hope you enjoy it. Thank you. Hello everyone, this is Tom Fox, and welcome to this episode of the FCPA Compliance and Ethics Report. I'm thrilled to have back the FCPA professor, Mike Kaler, who is continuing a conversation we began in an earlier episode. Professor, welcome back. Thank you again.
Thanks for having me back.
We've had some quite interesting writings this week, one in the form of a book review, one in the form of a judicial opinion, or at least a court ruling that we both were intrigued by. The first was a book review by Judge Jed Rakoff of the Southern District of New York of a book by Professor Garrett at the University of Virginia in Charlottesville, where the law professor criticized DPAs and NPAs, and Judge Rakoff used that book as, I thought, sort of a starting point to focus a little bit more and articulate a little bit more his criticisms of those settlement tools. In another case, we had Judge Richard Leon in the District Court of the District of Columbia refused to approve a deferred prosecution agreement for Fokker Industries. It was not an FCPA case, it was an export control case. But Judge Leon criticized the leniency that he viewed of the DPA based upon the admitted actions of Fokker. So I asked you, the professor, to come on and see if we might be able to talk about DPAs, NPAs, judicial oversight, and just get into a kind of an in-the-weeds discussion. I know you've got a lot of thoughts on this, and I really wanted to just explore this since we've now really unusually had two very well-respected sitting jurists make comments in an area that we've been talking about for some time. So welcome back.
It's actually three, because before Judge Rakoff's book review and Judge Leon's opinion this week, Judge Gleason, also in New York, opined on a DPA in a case involving a bank in 2013. Just by way of background, of course, none of this is FCPA specific, because NPAs and DPAs are used in other areas of law as well, but it's very much FCPA relevant. Because really in this new era of FCPA enforcement, the statistics are that corporate enforcement actions, 85% of them, involve in some capacity an MPA and a DPA. And these alternative resolution vehicles were brought to the FCPA context approximately 10 years ago in 2004. Congress did not authorize the DOJ to use these. These resolution vehicles are not specifically provided for in the statute. The DOJ, on its own initiative, as a matter of its own internal decision-making, came up with this. And I think it's been a flawed experiment, and with increasing frequency, others are viewing it as a flawed experiment, and how these resolution vehicles, I think, are toxic resolution vehicles that ought to be abolished. Judge Rakoff, to begin with, certainly this is not the first time he's voiced displeasure about how the DOJ or the SEC is resolving some of its enforcement actions. He's been a very vocal critic, and a very informed critic as well. He comes from a distinguished background of, I believe, both being a DOJ and SEC enforcement attorney in a prior life, and given his position in the Southern District of New York, is a very well-respected judge, as is Judge Leon. I think this is great, and these are nothing but defeats for the Department of Justice, because in both the cases, the original one was Judge Gleason in the HBSC matter, and in the Fokker, which I find very strange saying that word all the time, Fokker, but anyway, these were both situations in which the DOJ told the courts, you have no authority here.
Well, if you have trouble with
DOJ's position.
think about the World War I German aircraft. If you think at it in that manner, you probably won't have as much trouble saying it so many times. But the Judge Rakoff's criticisms, I think, are, at least in our community, well known. He's articulated them in public forums. I think in a prior article in the New York Review of Books, based upon a speech he gave. And he, as you correctly noted, he has not talked about these in the context of the Foreign Corrupt Practices Act, but in financial institutions and around those. But his criticisms, I thought, were particularly important, or that may not be the right word, but they're bringing the issue to an audience much broader than our community.
Right.
And he's starting a conversation that is cutting across a large number of lawyers, of companies, of practitioners, certainly law professors, who are now focusing their attention in their specific areas of legal expertise on what might be a correct way or a better tool to use to move forward. Does any of that make sense to you?
Well, it all makes sense to me. I mean, I've been writing and talking, including in my congressional testimony in 2010 about NPAs and DPAs and how they ought to be abolished. And let me just pause there. Some people may say, well, gee, that's radical. You're abolishing NPAs and DPAs. Well, let's start with the proposition that these are the new kids on the block. They're relatively recent inventions. These alternative resolution vehicles are foreign to most other jurisdictions of this world, have been foreign to the United States criminal justice system really up until the last 10 to 15 years. So in calling for abolition of these agreements, I'm not calling to abolish a long-standing, firmly entrenched way of resolving cases. These are new, and it's been a flawed experiment. And I think Judge Leon and Judge Rakoff and Judge Gleason's concern, I completely agree with you. It's bringing this to a much broader audience and starting a much needed legal and policy discussion as to how should criminal action be prosecuted. You know, our founding fathers never wanted it to be easy. Never envisioned that accusing someone of a crime, whether a natural person like you or me or a legal person, should be efficient, right? Ease, efficiency are not traditional aspects of criminal law enforcement. But you, time and time again, hear that as being really the primary justification for these.
If we could turn to Judge Leon and his comments, because in many ways I found them more focused, because it was a specific deferred prosecution agreement in front of him. And his comments perhaps were not as broad as Judge Rakoff's, but he was very, very critical, in fact rejected the DPA as too lenient. And this is really one of the few instances, other than certainly Judge Gleason, Judge Rakoff may have tried to comment or reject a DPA previously, but we had a judge saying, no, this is not sufficient. And that led me to think about what would be greater judicial oversight. And you have advocated for some time, get rid of these alternative settlement, sentencing, other mechanisms. Let's just go back to pleading guilty or not pleading guilty, or defending your case and being found not guilty or not being charged at all. But and so I've been trying to think through how we would have greater judicial oversight if there's a guilty plea and perhaps probation. Would that be something that you would consider on the table?
Well, I do think in 3, 5 to 7 years, these agreements will not be as prominent as they are right now. Leslie Caldwell apparently said just recently that even the DOJ is going to move away from these. Well, hey, I'm glad to hear you're getting the message, because it's a message that needs to be heard. You know, comparatively, to my knowledge, the only other country that is using DPAs or wants to use them at present, a lot of countries want them, of course, because they're easy and efficient, is the United Kingdom. And I think it bears mentioning that the United Kingdom completely rejected NPAs, but they were comfortable perhaps with DPAs. The British system, and this is just on paper because to my knowledge there's yet to be a UK DPA, so time will tell how this process works out, that the judge is going to be a more active participant not just on a here, take it or leave it basis at the end of the process, but a more active participant in whether a DPA is warranted, how the DPA is structured. In other words, the UK model is more judicial involvement very early on in the process. Now, that's better, I think, than the current U.S. model, but given my position that they should be abolished, I don't think that that's really the best solution, but it is a better situation than what I think we have now.
Do you think that a court or other body should have some sort of continued oversight for a company that pled guilty, or do you think that the simple plea of guilty would be enough?
Well, I mean, even in the traditional way of plea agreements and probationary periods, the court has oversight. The whole reason why the SEC needs to go to a court to get an injunction is because of the injunctive power of the court as an oversight power. So DPAs and really add nothing in many cases to things courts have always been doing, and that is overseeing perhaps the plea agreement or the probationary period that the criminal defendant is under. I mean, that's basic stuff.
So the monitor, for instance, which has been a component of DPAs and NPAs, occasionally appointed, occasionally agreed upon, occasionally no monitor yet reports to the Department of Justice on some sort of ongoing basis. Would you feel comfortable with some sort of oversight to that level, or do you think some other model might be appropriate?
Well, I think the concern that the judges have articulated, and indeed my concern, is not so much the future. Is this settlement agreement a sufficient way, a just way, a valid way to resolve the actual alleged criminal act? So you're really talking about a different thing. You're talking about forward-looking provisions. I'm talking about, does an MPA or a DPA necessarily represent a provable instance of, for instance, an FCPA violation? And I think the answer to that can be yes, of course, but I think in many cases, no. You know, it's interesting to note that the current criticism of Judge Leon, Judge Gleason, and Judge Rakoff seem to be on this lenient side of the spectrum.
Right.
But even Judge Leon noted that there could be instances in which it would be on the other side of the spectrum.
Sure.
Professor Garrett is mostly talking about the lenient side of the spectrum. I am and have always been more concerned with the other end of the spectrum, and that's the notion that these agreements are risk-averse business decisions that don't necessarily represent provable FCPA violations. And I'll just throw out a statistic for you. When the DOJ resolves an FCPA enforcement action via an MPA or DPA, there's only a 9% chance that in those cases an individual will be charged. You compare that with DOJ FCPA enforcement from 1978 to 2004, 90% of DOJ corporate actions resulted in related individual enforcement actions. Now it's materially flipped. And I think it's materially flipped is because back in the day, these were valid, legitimate, provable instances of clear violations. Now you have a situation where it's like, hey, what can we leverage? What can we extract from this company? What is this risk-averse company willing to settle on? I just don't think in a legal system based upon the rule of law that this is how things should happen.
So I guess the one of the values I see in DPAs is a deterrence going forward. Would you say that has any role in a guilty plea or other settlement that's brought to a court?
I don't think it has any deterrence effect because if the company behaves itself, it's going to disappear and it's like nothing's ever going to happen. If it had a deterrent effect, why do you have repeat violators? You've had companies in the FCPA context who have had DPAs and who have now are under scrutiny again, who have had DPAs and now pled guilty again. We've had recidivists in the FCPA context.
Well,
all the other banks, a lot of the banks have had DPAs. I mean, so I don't even think they have a deterrent effect. And indeed, the Department of Justice was asked this specific issue by the OECD in connection with its monitoring. And all the DOJ said, well, we don't know, it's just merely anecdotal. It's difficult to measure deterrence. So I don't even think they have a deterrent effect.
We probably should have, or at least I should have mentioned Leslie Caldwell's remarks when I started this, because I think that's one of the things that to me was significant about this sort of week of comments. We do have the Assistant Attorney General, at least if not agreeing with those observations by those jurists, perhaps acknowledging what they were saying. And I thought that was a significant move by Ms. Caldwell, and it's going to be interesting to see what she might implement in the way going forward.
Well, you actually saw this in FCPA enforcement in 2014 before Rakoff and Leon, because I don't have the numbers off the top of my head, but the use of MPAs and DPAs in 2014 was significantly less than in prior years. Now, I think part of that just happens to do with some of the conduct at issue. Part of that happened to do with Mara Benny was a repeat offender there.
Yes.
So anytime you're talking about a universe of 10, which again, there were 10 corporate enforcement actions, and in 2014, just one or two of those can statistically, sway the statistics, so to speak. But the percentage of DPAs and MPAs in the FCPA context in 2014 was actually lower than in prior years.
That, and I guess the other point I would concur with yours is the SEC's use of the administrative process, which seemed to take at least 3 or 4 cases right out of it. So I guess, Mike, we're nearly at the end of our time again. I, for one, really welcome this debate, particularly with these two jurists, because I think I agree with you. It's elevated it, or at least broadened it to a group beyond our little cohorts, and perhaps there'll be some more congressional hearing or other reasoned debate on it as well. Any kind of closing thoughts?
Congress is not going to abolish these. What do politicians love? They like more settlement amounts. They like the DOJ appearing that they're tough on crime. I think a congressman or woman is going to tread very lightly when it comes to MPAs and DPAs, because they look good. I mean, what's better than a multi-billion-dollar fine on the front pages of the Wall Street Journal and the New York Times? What's better than quantifying enforcement action and appearing that you're tough on crime? I mean, that's the problem here. These are so politically expedient. They're so useful to the DOJ. Companies like them. Well, anytime an adversary, two people who should be in an adversarial relationship, the DOJ, SEC, and the company like them, that should be a red flag that there's perhaps something wrong with them.
Well, on that note, I would like to thank you again. And once again, I would ask if anyone wanted to get in touch with you to follow up on any of your comments or any other reason, how would they do so?
Yeah, I can be reached at fcpaprofessor@gmail.com, and my website is fcpaprofessor.com.
Mike, thanks a lot. It's been a ton of fun.
Thanks.